Question 391. If a plaintiff wins a lawsuit based on the 1968 Civil Rights Act, the following remedies against the defendants are available, except A. Money damages for plaintiff's pain and suffering, B. Suspension or revocation of the license of the real estate agent whose unlawful actions led to the lawsuit, C. Money damages covering plaintiff's attorney fees, D. Punitive damages designed to discourage unlawful actions from recurring. Correct answer is B. Suspension or revocation of the license of the real estate agent whose unlawful actions led to the lawsuit. The 1968 Civil Rights Act, Fair Housing Act, primarily focuses on providing remedies to the victim of discrimination. The direct sanctions against a real estate licensee typically fall under the jurisdiction of state real estate licensing authorities, not directly as a remedy awarded by a court in a Civil Rights Act lawsuit. Compensatory damages, including those for emotional distress and pain and suffering caused by discrimination, are often awarded in Fair Housing Act cases. The Fair Housing Act allows prevailing plaintiffs to recover their reasonable attorney's fees and costs. This is a crucial element in ensuring access to justice for those who have experienced discrimination. Courts can award punitive damages in Fair Housing Act cases to punish defendants for egregious or intentional discriminatory conduct and to deter future violations. Discriminatory actions by a real estate agent can result in disciplinary measures against their license by the State Real Estate Commission through an administrative process. However, this licensing action is distinct from the remedies a plaintiff may receive in a lawsuit filed under the 1968 Civil Rights Act for the discriminatory conduct itself. Therefore, while both address discriminatory behavior, they operate through separate legal and administrative channels. The remedies in such a lawsuit focus on compensating the victim and deterring future discrimination. Question 392. Is the most important factor in determining a property's value? A. Design, B. Location, C. Utility, D. Age. Correct answer is B. Location. This is a long-standing principle in real estate, often summarized as location, location, location. When assessing a property's value, location stands out as the paramount consideration. This single factor encompasses a wide array of elements that significantly impact a property's desirability and, consequently, its price. Aspects such as proximity to employment centers, transportation networks, shopping, and recreational facilities are all tied to location. Furthermore, the quality of the neighborhood, including safety, community amenities, and the prestige associated with the area, heavily influences buyer interest and property values, often overshadowing the specific features of the dwelling itself. Question 393. The value of a property can increase significantly when its neighborhood includes lots and the houses built on them that are mostly similar in size and shape, describes the A. Principle of substitution, B. First law of housing, C. Principle of conformity, D. Principle of progression. Correct answer is C. Principle of conformity. Principle of substitution states that a buyer will pay no more for a property than they would for an equally desirable substitute property. It focuses on the availability of comparable alternatives. First law of housing is not a recognized principle in real estate appraisal. Principle of progression states that the value of a lower-priced property can be increased by its association with higher-priced properties in the same area. It's the opposite of the principle of regression, where a higher-priced property can be negatively affected by lower-priced ones. Principle of conformity states that property values tend to be highest when there is reasonable similarity in size, style, and age of the homes in a neighborhood. Properties that conform to their surrounding area tend to be more desirable and maintain their value better. Out-of-place properties, overly large, run down, or significantly different in style, can be negatively affected by the surrounding non-conforming properties. Question 394. The following occurs whenever a payment is made for an amortized loan. A. The amount applied to the principal rises. B. There is a balloon payment. C. The amount applied to the principal remains unchanged. D. Both A and B. Correct answer is A. The amount applied to the principal rises. A balloon payment is a large, lump sum payment due at the end of some loans, which is not characteristic of a fully amortized loan. In an amortized loan, each payment is applied first to the accrued interest, and the remaining portion is applied to reduce the principal balance. Over the life of the loan, one interest portion decreases. As the principal balance decreases with each payment, the amount of interest owed on the remaining balance also decreases. 2. Principal portion increases. Since the total payment amount typically remains constant, as the interest portion decreases, a larger portion of each subsequent payment is applied to reduce the principal. Question 395. The types of mortgage default insurance include: A. Partial coverage. B. Full coverage. C. Co-insurance. D. All of the above. Correct answer is D. All of the above. Mortgage default insurance is typically required for conventional loans with a down payment of less than 20%. It protects the lender in case the borrower defaults on the loan, but it does not protect the borrower. Partial coverage covers a portion of the lender's losses in case of default. The specific percentage of coverage will vary depending on the program and the loan-to-value ratio, LTV, of the property. Full coverage covers the lender's losses up to a specified limit in case of default. This limit is typically the outstanding loan balance but may have limitations. Co-insurance is a shared risk arrangement between the lender and a private mortgage insurance company. The lender pays a portion of the premium, and the private mortgage insurance company covers a portion of the losses in case of default. The specific sharing arrangement will vary depending on the program. Another variety of coverage, self-insurance, puts the risk of default with the lender. Question 396. A trust deed with a balance of $75,000 was sold to a businessman for $50,000. Such a practice is called: A. Liquidation. B. Discounting. C. Securitization. D. Remarketing. Correct answer is B. Discounting. Liquidation typically refers to the process of converting assets into cash, often to settle debts or close a business, while selling the trust deed generates cash. Securitization is the process of pooling together various loans, like mortgages or trust deeds, and then selling interests in these pools as securities to investors. Remarketing generally refers to efforts to promote or sell something again, often after a previous attempt. While the trust deed is being sold, the term doesn't specifically address the price reduction. Discounting occurs when a debt instrument, like a trust deed or a bond, is sold for less than its face value or outstanding balance. The difference between the face value and the sale price represents the discount. In this scenario, the businessman purchased the right to receive $75,000 in future payments for a present value of only $50,000, effectively receiving a $25,000 discount. This discount compensates the buyer for factors such as the time value of money, the risk of default, and the potential for a lower than market interest rate on the original loan. Question 397. A plaintiff can ask a court to issue a writ of attachment against the defendant's property to satisfy the judgment being sought. The resultant attachment liens are: A. Valid for up to 5 years. B. Not renewable. C. Enforceable by the sheriff. D. None of the above. Correct answer is C. Enforceable by the sheriff. When a court issues a writ of attachment, it directs the sheriff, or another designated levying officer, to seize the defendant's property. This creates an attachment lien on the property, securing it as potential collateral to satisfy a future judgment. If the plaintiff ultimately wins the lawsuit and obtains a judgment against the defendant, they can then seek to enforce that judgment. If an attachment lien is in place, the plaintiff can request the court to issue a writ of execution, again directed to the sheriff. The sheriff then has the authority to sell the attached property to satisfy the judgment debt. Judgments in California are generally enforceable for 10 years and renewable. Question 398. A good faith deposit could be A. A diamond ring. B. A promissory note. C. Anything the parties agree has value. D. All of the above. Correct answer is D. All of the above. A good faith deposit, also known as earnest money, is intended to demonstrate the buyer's serious intention to purchase the property. Legally, it can be in various forms as long as the seller agrees to accept it as having value. If the seller is willing to accept a diamond ring, A. as a good faith deposit and both parties agree on its value, it can serve that purpose. A promissory note, B. as a written promise to pay a specific sum of money at a future date. If the seller trusts the buyer's creditworthiness and is willing to accept a promissory note as a demonstration of good faith, it can be used. However, sellers often prefer immediately liquid assets. Anything the parties agree has value, C. is the most encompassing and accurate statement. The key is the mutual agreement between the buyer and seller that the offered item or promise holds value and signifies the buyer's earnestness. Cash or a check are the most common forms of good faith deposits due to their immediate and easily ascertainable value. The law allows for other forms as long as there is a meeting of the minds between the parties regarding that value. Question 399. The land description method that relies on sections, townships and ranges is the A. Recorded map method. B. Social grid technique. C. Government survey record. D. Metes and bounds method. Correct answer is C. Government survey record. The land description method that relies on sections, townships, and ranges is the government survey record, also known as the Public Land Survey System or PLSS. This system, established by the U.S. government, divides land into a grid using principal meridians, north-south lines, and baselines, east-west lines. Townships are 6-mile by 6-mile squares formed by these lines, and each township is further divided into 36 1-square-mile sections. Ranges indicate the distance east or west of a principal meridian, while townships indicate the distance north or south of a baseline. This method provides a systematic and standardized way to describe and locate land across much of the United States. Question 400. A mudslide leading to severe property damage would be an example of A. Avulsion. B. Erosion. C. Soil decline. D. Corrosion. Correct answer is A. Avulsion. Soil decline refers to a reduction in the quality and health of soil over time. Soil decline can be caused by various factors, both natural and human-induced, such as unsustainable farming practices, deforestation, overgrazing, pollution, and climate change. It has significant negative impacts on agricultural productivity, ecosystem health, water quality, and even contributes to climate change. Corrosion is a natural process where a refined metal is gradually degraded and transformed into a more chemically stable oxide. This deterioration typically occurs through a chemical or electrochemical reaction between the material, most commonly a metal, and its surrounding environment. Familiar examples of corrosion include the rusting of iron, the tarnishing of silver, and the formation of a patina on copper. Erosion refers to the gradual wearing away of land by natural forces like water, wind, or ice over an extended period. Avulsion refers to the sudden and perceptible loss or addition of land by a violent act of nature. A mudslide, being a rapid and dramatic movement of earth causing significant and immediate change to the landscape, fits the definition of avulsion.